Our next guest is also our host, is Mark Furman from the law firm of Tarlow, Breedhart, and Rogers, and his segment is always Litigation and the Law.
Hello, Jeffrey. Great to be with you.
Great to be with you too, Mark. What is our topic today?
Well, we've talked a lot about the Wage Act here in Massachusetts, and we frequently talk about Chapter 93A, which prohibits unfair or deceptive business practices, very common claims in the litigation world. Here we have a case that was decided by the First Circuit Court of Appeals in the federal court, and it sort of combines the two. And I thought it might be an interesting case for business owners to be aware of. Someone named Darrell Debnam filed a lawsuit against FedEx, claiming both wage payment claims and claims under 93A. So the Wage Act protects employees. Chapter 93A protects consumers in one section, and in another section protects businesses from unfair or deceptive business practices by other businesses. So Mr. Debnam's situation was somewhat interesting. He signed a form agreement with FedEx that described himself as an independent contractor. And under that agreement, FedEx retained certain rights, including to have standards regarding the appearance of drivers and vehicles, qualifications of people employed as drivers, and to the right to terminate the agreement, among other things, on short 30 days notice. So he filed a claim that seemed to allege, on the one hand, that he was effectively an employee of FedEx because he has a right to, FedEx has all these rules, and on the other hand, he wanted to sue FedEx for Chapter 93A. So at the beginning of the case, the FedEx moved to dismiss the 93A claim, and the court allowed it, saying, hey, all you've alleged is an employee-employer relationship, so forget about your 93A claim, and the case gets booted out of court. The district court said that you're not an employee, so you can't have a wage claim. You're an independent contractor. So you remember at the beginning I said the court kicked out the 93A case because of the employment relationship. So the plaintiff now has lost all its claims, and the case goes on appeal to the question of whether or not, in light of the finding that it was an independent contractual relationship and not an employee relationship, whether the 93A claim should be reinstated. 93A, you know, is this powerful law, because if you win under 93A, if there's a finding in your favor, you get attorney's fees. So it's one of those rare circumstances where you can recover your own attorney's fees if you win under 93A. The usual American rule is everybody pays their own legal fees, unlike the British rule or the Canadian rule, which is loser pays. So that's a huge advantage. And then on top of that, where 93A, you prevail under 93A, if you are able to establish a knowing or willful violation, you can recover not less than double nor more than triple your actual damages. So it's a huge, it's a hugely powerful claim that plaintiffs obviously want to bring anytime they can, and defendants want to have dismissed as quickly as they can, because it really changes the risk-reward, cost-benefit analysis when you have a lawsuit.